I think so. Yeah.
Hi, good morning, ma'am.
Good morning.
Hi, what case are you here for this morning?
For Genevieve East, in internal property services.
Okay, thank you.
Good morning. This is Tuesday, May 3rd, 2022. I am Judge Martin. I have a mixed docket this morning of general civil cases and landlord tenant cases. As parties arrive, my secretary is working diligently to get everyone matched up to inform me of which cases are ready to be heard. Mary Ann, who's ready to be heard?
USA Bio.
Mary Ann, I know I saw that file.
Oh, did you tell her you got the sign?
No. That's for the box.
Hold on, Mary Ann, let me go look for it again.
Here, I'll look.
I don't know where to tell you to look is the problem.
Marianne, she sent it down accidentally. I'll bring it up.
Thanks, Taylor.
I heard Taylor say she was bringing it up. It's 215890 GC USA BioCare LLC versus Diane Spencer and the estate of Stanford. May I have your appearances, please?
Good morning, Your Honor. Joanne Prey standing in for Attorney of Record Joseph Levine for USA BioCare.
Good morning, Your Honor. John Tatone appearing on behalf of Erica Drew, who's the personal representative of the estate of Eric Howard Stanford, her father.
Ms. Prey, was there service made upon Diane Spencer?
I believe so, Your Honor.
When I reviewed the file yesterday, I did not see a proof of service in there, which is why I'm asking.
Your Honor, I'm standing in for Mr. Levine. I could check the file if you would like me to.
You don't need to do it right this second. I just am curious when the defendant number one's not served and there's no default file, and we're here for a pretrial this morning. Have the parties had an opportunity to speak?
I have spoke to Mr. Levine. There is another attorney who is involved on behalf of Diane Spencer, and I've spoken with him as well. It's kind of complicated, but this whole thing stems from USA BioCare performing certain services.
Mr. Tatone?
Yeah.
Not to cut you off, but I've read the file in its entirety, the underlying contract, as well as the everything else that's been filed, the affirmative defenses and whatnot. So my question was only, had you spoken and what's the status of the matter?
The status of the matter is we have not resolved it. It's my understanding that Diane Spencer's attorney has proposed making payment in full to the plaintiff.
Who is Diane Spencer's attorney?
His name is Avery Bradley.
Your Honor, my understanding per Mr. Levine is that the case is settled, that Spencer is going to be paying the claim, and once that happens, we would be submitting a dismissal order within 7 to 14 days.
Ms. Spencer is going to be paying in 7 to 14 days?
I believe they're waiting on an entry of an order in Wayne probate, and once that happens, we'd be submitting a dismissal order.
So if the court adjourned the case to the next civil docket day, which would be June the 7th, would this matter be better along?
I believe so, Your Honor.
Do you agree with that, sir?
Yes,
Court will adjourn the pretrial in this matter to June the 7th, 2022 at 9 a.m. back here in courtroom number 1. If the order comes from the probate court and funds are received and dismissals received before then, the court will just sign it. You don't need to reappear on that date. But if we do reappear, we'll set a scheduling order for how we'll proceed. Anything else on behalf of the plaintiff?
No, Your Honor, thank you.
Anything else on behalf of the estate?
nothing, Your Honor.
Thank you so much. You both have a wonderful day.
You
You
too.
too.
Thank you.
Thank you. So Taylor, it will probably help if I sent back down the right dismissal. Let me see if I can find this.
It's fine. You can hold it for now.
No, well, I remembered the case as soon as he said the name. I was like, wait a minute, I read that case because it's kind of thick for a first pretrial. Marianne, I can tell you what happened. Taylor got me so distracted talking about community day at the court that I just attached stuff to the wrong file.
Judge, I'm putting Mr. Narlock and Miss East in a breakout room right now.
Thank you, ma'am.
Yep, you're welcome.
Mr. Kimball, your matter is scheduled at 9:15. This court's policy is 15 minutes after the scheduled start time. So if no one from Infinite Auto has appeared by 9:30, I'll call your case and get you on your way, sir.
Thank you.
You're welcome.
Good morning, sir. What is your name, please?
James Flynn.
Thank you. I'm sorry, what's your last name?
Flynn, Flynn.
Thank you.
Would you like the case number?
That'd be helpful, sir. Yes.
220200 GC.
Thank you, sir. You're here on behalf of Tri-State?
Correct.
Thank you.
You're welcome.
Mr. Flynn, those matters are scheduled at 9:30. I have not seen the attorney yet for the 34th District Court. The court's policy is 15 minutes after the scheduled start time. So if Mr. Hitchcock is not here by 9:45, I'll get your cases called and get you on your way.
Okay.
Thank you.
The person who just signed on is Brittany T. Can you hear me?
945-220345, Mary Ann.
Yes.
Thank you.
Mr. Narlock, when Ms. East comes out, are you ready to proceed?
We are, Your Honor. They are, both the defendants are here. I'm showing that there's no update with regards to your Sarah application. Yep.
Sir, let me actually call the case first.
Sure. Yes, my apologies, Your Honor.
No worries. This is 220221 LT Integrated Property Services versus Genevieve East and Ivan Dunham. May I have your appearances, please?
Yeah. Good morning, Your Honor. Brian Narlock, P number 83990, appearing today on behalf of plaintiff.
Ma'am, would you state your name and then sir?
Genevieve East.
Ivan Durham Jr.
Thank you. Today is the day and time for hearing on plaintiff's request to lift the Sarah stay. The parties were last here on February 2nd, 2022, at which time the defendants would have indicated that they had made application for assistance through the COVID Emergency Rental Assistance Program. The stay that was put in place indicated that within 45 days, if plaintiff had not received payment in full or communication from defendants that they were ineligible, that they may make the request to the court to lift the stay and proceed. Mr. Narlock, you were starting to say that there is no update.
That is correct, Your Honor. I did have an opportunity to speak with the defendants. They indicated that their application still shows processing. I did explain the immediate need for them to get in contact with somebody from Sarah. It looks like that they will likely be approved. We're just waiting on a determination of whether or not they've been approved or not. With regards to them appearing here today, she did indicate, the defendants did indicate that they are going to make future monthly payments. So we're just requesting a short adjournment to allow this application hopefully to be processed by the next time we're here. Otherwise, the parties will likely enter into some sort of an agreement at the next hearing.
Sir, what do you consider a short adjournment?
I would say something within 30 days, Your Honor.
We can do it on this court's next civil date, which is June the 7th. It's a little bit more than 30 days, but
That would be fine, Your Honor.
Ms. East and Mr. Dunham,
Yes.
when was the last time you had communication with the agency you made your Sarah application to?
I checked the internet yesterday to see that they changed it on April 27th. I've called 2 weeks ago and they told me that I'm waiting for a caseworker.
Do you have any objection to this case being adjourned?
No, ma'am.
Case will be adjourned to June the 7th, 2022 at 9:30 a.m. It'll be back on Zoom courtroom number 1, Judge Martin. The Civil Department will mail notices out. Anything else on behalf of the plaintiff?
Nothing further, Your Honor.
Anything else on behalf of Ms. East and Mr. Dunham?
No, ma'am.
Thank you. I'll see you all on June the 7th. Have a good week.
Thank you.
Thank you, Your Honor.
You're welcome. This is 214837 SC, Kelvin Kimball versus Infinite Auto Protection.
Yes.
State your name for me, please, sir.
Kelvin Kimball.
Mr. Kimball, today is the day and time set for hearing on your small claims affidavit and claim. The court has had the opportunity to review your file in its entirety, and I want to thank you for including so many invoices and communications. It was very insightful as to the status of the matter, and I see that you provided information that shows that Opulent Marketing is actually the one that's doing business as Infinite Auto Protection, and that service has been made upon them as directed by the court. The matter was scheduled for 9:15 this morning. It's now 9:30 a.m. by the court's clock. Is there anyone here on behalf of Infinite Auto Protection or Opulent Marketing? The defendants having been properly served by the plaintiff and failing to appear as directed by this court. Mr. Kimball, is it your position that $5,459.25 remains due and owing to you from Infinite Auto?
Yes, it is, Your Honor.
And sir, you've had $128.25 in cost to date.
Correct.
You're seeking a total judgment of $5,587.50.
Yes, Your Honor.
That proposed judgment is stapled inside of the court's file. The court will sign it at this time. The civil department will mail a copy to you at the address we have on record. Is there anything else in this matter, sir?
No, Your Honor.
Mr. Kimball, you have a wonderful day. Thank you for joining us this morning.
Thank you, Your Honor. Bye.
Bye-bye. Two 15686 LT. This is Rawsonville Woods versus Gunn.
Good morning, Your Honor. Robin Maccabee, Appellate's Law, P 64575, on behalf of the plaintiff, Rawsonville Woods.
Ms. Maccabee, have you had any communication from the tenant Gunn in this matter?
No, we have not, Your Honor.
Today is a day and time set for hearing on plaintiff's request to lift the SARA stay that's been in place since January 5th, 2022. 117 days has passed since the entry of that stay. Ms. Maccabee, has your client received payment from the SARA program?
No, they have not, Your Honor.
Matter having been scheduled at 9:15, it now being 9:33 a.m. by the court's clock, defendant having failed to appear, ma'am, how do you wish to proceed?
We would request entry of a default judgment for possession only due to the defendant's failure to appear for a 9:15 a.m. hearing. Rent to retain possessions, $8,388.26. Court costs are $164. The total amount due is $8,552.26.
Defendant having failed to appear as directed by this court, default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $8,388.26, $164 in court costs for a total of $8,552.26. Plaintiff's office to submit the judgment to the court. Anything else in this matter, ma'am?
No, Your Honor, that's it. We'll submit the judgment.
Thank you. Have a good day.
Thank you. You too.
These are 220200GC and 220201GC. These are both Tri-State Communications versus 34th District Court. May I have your appearances, please?
Good morning, Your Honor. Steve Hitchcock. I'm appearing on behalf of the District Court. This actually is a City of Romulus obligation, though. It was titled wrong in the complaint.
Mr. Flynn, would you unmute yourself and state your name for the record?
James Flynn, Tri-State Communications.
Thank you. Mr. Hitchcock, the problem from this court's perspective is that 34th District Court, where I'm sitting right now, is a named party in this matter. I don't think it's appropriate for this court to sit and make any determination as to the underlying facts in this case. There was some indication that this matter would be paid and resolved, and this court was anticipating a dismissal.
Well, and Your Honor, I did take this through council and got it approved, and we did pay Mr. Flynn the amount of the invoices, but he now has tried to attach a big interest payment to each of these amounts that we don't agree to pay.
Mr. Hitchcock, again, in as much as this court is a named party, although you indicate that it's actually the responsibility of the City of Romulus, I don't think it's appropriate for this court to sit on this matter, and I will disqualify myself and send the files, both of them, downstairs to the court administrator to have this case reassigned to a different court. If the parties resolve the matter in the interim, that's between the parties, but this court, I don't think, can appropriately sit on these matters.
I agree, Judge. Thank you.
Mr. Flynn, do you understand the comments I just made?
I do.
I'll send the files downstairs and the matter will get reassigned and you will receive notification of the next step in these procedures, sir.
Okay.
Anything else, Mr. Flynn?
No, I just don't understand why the court refuses to pay. I don't understand why a company like myself would have to file a judgment against a municipality like yourself, and incur a cost to try and collect the money. Now, just like any other bill that everybody gets in the mail, most bills incur a finance charge or a late fee, whether it be a parking ticket or whether it be your DTE energy bill. So I find that the court should be responsible for the finance charge. In addition to that, we are not asking for any more finance charge above and beyond that. So basically, this is still a running invoice, which means they could still be incurring that finance charge because the balance wasn't really paid.
Mr. Flynn, I understand your statements, but as indicated on the record, because the court is a named party, I do not believe that it's appropriate for this court to sit on this matter. It will be reassigned. The court administrator will make sure that notice is processed and sent out. Anything else, Mr. Hitchcock?
Nothing further. Thank you, Judge.
Thank you. Mr. Flynn, thank you for your patience this morning, sir. Have a good day.
Thanks, you too.
Mr. Popoff.
Good. How's it going?
It is going wonderfully, sir. How are you?
I'm okay. We're in different places now. It took me a second to realize.
I saw your name on the filings and congratulations on being at the firm.
Thank you.
I've known Ms. Burnt for 20 years and Mr. Beach for not quite as long, but close.
Yeah, they're Carol. She's not with. It's Lloyd and McDaniel now. Actually, they purchased the firm. As I came in, that happened. So
Kim Burrows is here.
Yes.
Ms. Burrows, would you like to go into a breakout room and discuss this matter with the attorney from Credit Acceptance?
That's fine.
Thank you. You're going to see an invitation to join the breakout room, ma'am.
Okay.
This is 213609. It's not. This is 190781GC Credit Acceptance Corporation versus Kim Burrows. May I have your appearances, please?
Good morning, Your Honor. Alexander Popov appearing on behalf of plaintiff.
Good morning, Your Honor. Kim Burrows.
Ms. Burrows, we're here this morning on your petition for an installment payment. There was an objection filed by plaintiff's office. You had an opportunity to speak to the attorney in this matter?
Yes, I did.
Have you come to any resolution, Mr. Popov?
I believe so, Your Honor. We try to meet in the middle. I think we agree on a $250 a month payment plan.
Beginning when?
Ms. Burrows, would you like to start at the middle of this month or the beginning of this month?
Well, so you'll have another one payment coming out this Friday. So it depends on when you take the garnishment thing off. So it take the garnishment thing off, then we could start it. It's May, once a month.
Why don't we do the beginning of next month, the first of each month?
Well, I only get paid twice a month.
Ms.
So
Burrows,
yes,
let me stop you for 1 second. Is it your agreement to pay $250 per month?
I'm sorry. Yes, Your Honor.
And you're starting to say you get paid twice a month. When are you paid, ma'am?
So we get paid this Friday, and then which is the 6th, right? And then again on the and then again on the 20th. So the beginning of the month by like the 11th or something like that would sound good. So I won't be late. I need to have it like my first check of the month is better for me because I already got 2 installments that I'm paying to, and it's public record. You could probably see that too. So
we do 250, well, not we, if the order indicates that the payment will be $250 per month beginning on June the 11th, Mr. Popoff, would that be acceptable?
That's yes, that's acceptable.
There was not an order that came up with the file, but Ms. Burrows, the court will sign an order that indicates that your payments will be $250 per month, with the first payment being due on June 11, 2022. The order will release the garnishment that's currently in place, and any funds that are currently being held by your employer will be released to the plaintiff's office, which will decrease your balance and of course help you move towards getting this judgment satisfied, okay?
Thank you.
Anything else on behalf of the plaintiff?
Nothing further, Your Honor.
Anything else, Ms. Burrows?
No, that's it, Your Honor.
Thank you, ma'am. You have a wonderful day, okay?
You too. Thank you.
Thank you. Good to see you, Mr. Popoff.
Good to see you too, Your Honor. Thank you, Ms. Burrows.
This is 213609SC. This is Roy Jones Sr. versus Marshall Whitehead. This is a small claims matter that was scheduled at 9:30 a.m. It is now 9:47 a.m. by the court's clock. Roy Jones Jr., Marshall Whitehead. Plaintiff and defendant both having failed to appear this morning. Notice having been sent to the parties on March 21st, 2022. The court having checked the register of actions and there being no update, this matter will be dismissed.
Before we begin, Robert, I have to advise you of certain rights and entitlements you have in these matters. First and foremost, you never have a right to have an attorney present in these proceedings.
Miss Tool, can you please join breakout room 1?
Good morning, sir.
Good morning, Your Honor.
I haven't seen Ms. Leeson as of yet, but the case isn't scheduled till 10.
Oh, I thought the opposing counsel was Hal Burke.
I haven't seen. Oh, I misread your note. I'm sorry. You're correct.
And Mr. Burke and I have exchanged a couple of emails on this already. I don't remember where we left things, so.
Mm. Good morning, sir. They just joined us with the tie and the suit jacket. Your name, please.
Marshawn.
Thank you.
I'm sorry, I didn't hear that.
Jay Bake.
McEady.
Marchant McEady.
Marianne, this is the 10 o'clock 963352 GC. This is asset acceptance versus Marchant McEady. Do the parties need an opportunity to speak?
Probably not. It's just his objection. Perhaps we just let him handle his motion.
Your appearance, please, on behalf of the plaintiff.
J. Latif Beg, BAIG, P36820, appearing on behalf of the plaintiff and the attorney of record.
And sir, would you state your name again for the record? Mr. McEady.
Oh, Marchant McEady. I'm sorry. I thought you was talking to him.
Thank you. You're fine, sir. Today is a day and time set for hearing on your objection to garnishment. The plaintiff did file a response. Did you receive that response, sir?
No, ma'am.
court received a response on April the 18th, 2022. Plaintiff's office indicates that they served you at the same address that appears on your objection to garnishment. Their response provides that your objections are not valid and do not meet the requirements of MCR 3.101K. That your objections may only be based on the garnishment proceeding itself and may not be used to challenge the validity of the judgment previously entered. That the issuance of the garnishment objected to was proper and defendant has given no valid reason why this garnishment should be set aside. They're asking that the court deny your objection to the garnishment and order the garnishing defendant to turn over all withheld funds to plaintiff's office. Mr. McGeady, the court did receive and review the objection to garnishment. You indicate that because the case is over 25 years old, it should be deemed invalid and expired, sir. Would you care to explain your objection to the court?
Yes, I never even was aware that this was, because my knowledge of this is, they said I had property that belonged to them in the writ. Now, this was over a car that I bought from a company or something like that, and it kept breaking down. I returned the car to them, and we were all squared off. And 30 years later, I owe them money. I never sat in on the judgment. I've had the same address for the last 12 years, and before that, the same address for years on hand. They never contacted me. They never sent me any mail about this. And then all of a sudden I get a threatening, my job tells me I was up for a promotion, executive chef. And my job tells me they got a letter from someone threatening them to garnish me, which made me look bad, and I didn't get my promotion. And if this was on my credit or anything, I would have taken care of this. I feel like they just was sending letters to where? And then I owe them money. I would have fought them tooth and nail. It just seemed ridiculous to me that they can come after me 30 years later for something I know I paid off. I gave back the car because the car was a lemon. The lemon law hadn't really came in effect yet. So we settled it back then. And I never went to court saying that I owe them money. They said a court, because they were sending letters to old addresses. I think that was a dirty thing to do. I've never not have an address. I've paid my child support, I've paid my taxes. How could this just come up out of nowhere and they've never contacted me personally? And then my job tells me, oh, we got a threatening letter. We have to pay you. We have to pay them.
Anything else, Mr. McEady?
No, ma'am.
On behalf of the plaintiff, sir.
Yeah, it's just what I've heard Mr. McKeady state is reasons for attacking the judgment, and according to the court rule, that's not what is mandated by the court rule, and as far as a valid objection. And then with respect to property of the defendant, I think he's misunderstanding. It's property that the garnishee defendant has control over. So his objections is a misunderstanding of what property is actually being subject of the garnishment. So for those reasons, Your Honor, he does not meet any of the objections that are mandated, that are set forth in the court rule. Thank you.
Anything else, Mr. McEady?
On the paperwork, it says plaintiff has property belonging to the defendant has property belonging to the plaintiff. I don't have any property belonging to them. I never did. They received their property.
Mr. McEady,
Yes,
is it
ma'am.
possible, I don't know what paper you're looking at, but is it possible that the paper says the garnishee has property?
Plaintiff knows or with good reason believes that the garnishee is in debt to or possesses or contains property belonging to defendant.
Mr. McEady, what the garnishment indicates is that plaintiff's office has reason to believe that monies are owed to you by the garnishee, which would be your employer in this case, as the garnishment that you object to was submitted to your employer, that being the Ford Yacht Club. And as indicated by the plaintiff, sir, this case was filed back in 1996, but plaintiff's office did file requests to renew the judgments. Those requests were filed in November of 2006, and another renewal was filed in September of 2016. The plaintiff is accurate in citing the court rule. Your objection to garnishment has to be limited to something being wrong with the garnishment. The typical things that could be the basis for objection to the garnishment are that the funds are exempt for some reason. That's not what you alleged. That there's bankruptcy proceedings which would stop the garnishment, that you have an installment payment order, that the judgment has been paid. Something has to be technically wrong with the garnishment, a reason for the court not to proceed. The court understands what you're saying, and what you are doing is attempting to attack the underlying judgment, which is not what you're allowed to do through an objection to garnishment. So what this court has to do is follow the court rule and find your objections invalid and enter an order directing Ford Yacht Club to release all withheld funds to the plaintiff's office and continue withholding funds from your payroll until the outstanding judgment is paid in full.
I think it is. I think they already took everything.
They took everything that's due on the judgment, sir?
Yes, ma'am.
I don't see a dollar amount, so I don't know. The attorney's office might be able to confirm whether or not it's been paid.
Okay, it was $8.90 and 3 cents, and it's been already taken.
Mr. McEady, if it's been paid in full, the plaintiff's office will process that payment and hopefully file a satisfaction of judgment with the court, which will indicate that the matter has been paid in full and closed out, okay?
Okay.
Your Honor, although I'm covering for plaintiff's counsel, at least from the ledger that I'm seeing, and Mr. McEady may want to contact plaintiff's counsel's office just to confirm, but it looks like it's almost paid off. I think there's $80.09 remaining. He may.
No, sir. No, sir. They took exactly what they were supposed to take. It was $890.03. They took it twice, $445.01, $445.01, and then another time this check that just came out, they took 1 cent. This check I just got paid, they took 1 cent from me.
That's why I prefaced my comment that you should contact plaintiff's counsel to verify. I'm covering, and just from what I'm seeing, that it's almost paid off. It may very well be paid off, but I'm just giving you whatever information that I have currently.
But how that doesn't
Anything
make
else on behalf of the plaintiff?
No, Judge.
Mr. McEady, was there something else? I interrupted you just now.
that doesn't make sense, ma'am. How they said they was taking it in two big chunks. They took 2 big chunks from me. And how is he saying that I still owe them $80? Now they're gonna come
Mr.
up with.
McEady?
Yes, ma'am.
Listen, I'm interrupting you because I can't answer your question and he can't either. But on your notice of hearing for this hearing, you will see a phone number for the plaintiff's attorney. Call them to confirm that it's been paid in full.
Okay. Sorry.
Understood?
Yes, ma'am.
No. I hear your frustration, sir. It's fine. Call them, confirm that it's been paid, and then you'll get the satisfaction of judgment, and this matter will be closed out, okay?
Okay. Thank you.
You have a wonderful day,
Judge.
sir.
Thank you.
Thank you.
Thank you.
Mr. Joseph, are you ready to proceed? Ms. Toole, are you ready to proceed?
Yes, I am.
Let's see if we can get the attorney. Joe Joseph. Ms.
Judge-
Toole, he might be in another courtroom, so I'm gonna.
Judge, I
pass
am.
this matter
They're gonna
briefly.
pass. They're gonna pass my matter so I can handle your case. Sorry, it's my 8:30 docket that's seemingly never ending.
This is 220345 LT. This is Southport Apartments versus Brittany Toole. May I have your appearances, please?
Thank you. Yes, for the record, Joe Joseph on behalf of the plaintiff.
Ms. Toole,
Yes.
start your video and state your name for the record, ma'am.
Brittany Toole.
Thank you. Today is the day and time set for hearing on plaintiff's request to lift the Sarah stay. Stay went in place back on February 9, 2022. 82 days has passed. The parties have had an opportunity to speak this morning. Mr. Joseph, how are we proceeding?
Thank you. I've spoken with defendant, gone over some options with her. We are agreeing to a consent judgment of possession with a total amount of $5,359 that's due and owing. That is inclusive of $154 in court costs. Defendant will have until May 20th to pay that, or writ may issue after. I have given her information regarding MCR 4.201, explained to her essentially, that it is just a possession judgment, not a money judgment. It looks like a SIRA check was mailed out in January, and the whereabouts of that have been unknown for quite a while. So hopefully she can figure that out. But in the meantime, she has consented to allowing us to sign her name to a judgment to this effect, and we would submit that to the court if the court is satisfied.
Ms. Toole, do you agree that $5,205 is due in rent and $154 in court costs
Yes.
for a total of $5,359?
Yes.
And ma'am, Mr. Joseph has indicated that the Sarah agency submitted a payment back in January. Have you been able to follow up and figure out where that payment
I've been
went or
following
was
up.
mailed?
I've been following up every month consistently, and they've been giving me the same answer for I don't know how long. And I'm really getting frustrated. I just called last week about this. I call every month about this check, and they keep giving me the same answer, and I'm not sure what to do.
What was the amount of the
had
check that was mailed in January?
4,900. I don't know the exact amount, but it was 4,900.
Ms. Toole, here's the issue. The Sarah stay is only good for 45 days, and when plaintiff has not received payment in full, meaning they have not received this January check and been able to apply it against the outstanding rent, and you do not object to the balance that Mr. Joseph placed on the record, the court's in a position to enter judgment in the amounts indicated by Mr. Joseph. Understood?
Yes, understood.
And he further indicated that you've agreed to allow the plaintiff's office to sign the consent judgment on your behalf. Is that your understanding, ma'am?
Yes, I kind of understand it. I'm still kind of confused about it. I'm honestly, I don't know what's the best option for me, to be honest.
Ma'am, your best option at this time is whatever document is filed with the court that you immediately follow up with whomever you made your Sarah application to, because if there's a check outstanding of $4,900 some odd dollars from January, it went somewhere, and if it hasn't been negotiated, I'm not sure why they could not reissue the check to Southport.
Yeah, they said they're in the process of investigating, but they've been telling me this since February. And I've just been getting the runaround as of right now.
Ms. Toole, the matter before the court this morning is as to the rent that's due and owing. And again, as you've not indicated you have any objection to the amounts Mr. Joseph placed on the record, the court will sign the judgment that is filed by Southport Apartments, okay?
Thank you,
Okay.
Judge. Do you want us to submit it as a consent or just as a judgment by hearing? It doesn't really matter.
You can submit it as a judgment by hearing. Ms. Toole does not object. There's no tribal issue if she does not object to the rent that's claimed due and owing.
Thank
And
you.
maybe this document will be sufficient to get the Sarah agency to look into this January check. Anything else on behalf of Southport?
Nothing further. Thank you.
Anything else, Ms. Toole?
No, how long will it take to get those documents so I can send that information over to Sarah?
Plaintiff's office should have it filed within the next day or two. This court signs them the same day we receive them, and they'll be mailed out to you at the address that's on the file.
Okay, thank you.
Okay, thank you, ma'am. Thank you, Mr. Joseph. Have a good day, sir.
Thank you. Can I get a breakout room with Mr. Perry? Thank
Mary
you.
Ann will take care of that.
Thank you.
This is 220503 GC. This is Beaumont Health versus Tiffany Fleeson.
Hello, hello, Your Honor, Hal Burke for the plaintiff P69068.
John Evanchik on behalf of the defendant Tiffany Fleeson, P66157.
Today is the day and time set for the pretrial in this matter. Have the parties had an opportunity to speak?
We have,
Your Honor, and we need to do a little bit of discovery. My client is hoping to submit these medical bills to the proper insurer and maybe get them paid.
How much discovery?
I'd ask for 60 days.
I agree with that, Your Honor.
$60 days discovery and the parties back on July the 6th, 2022 at 9 a.m. in courtroom number 1. Anything else on behalf of the plaintiff?
Nothing, Your Honor. Thank you.
Anything else on behalf of the defendant?
No, I'm all set, Your Honor. Thank you.
See you
Excuse
all
me,
in
Your
July.
Honor.
Have a good afternoon. Ms. McLemore?
Yes, Mr. Perry is my client, and I think he just got put into a breakout room with plaintiff's attorney.
Mary Ann will get you moved into the breakout room.
Yes, thank you.
You're welcome. Ms. McLeod? Ms. Hemingway McLeod?
Hello.
Yes, ma'am. What are you here for?
I'm coming back because I was waiting for a response from the CERA program, and I just applied for the ERAP. I was with Lakeshore.
Have you, I'm sorry, let me see. Have we seen Mr. Herman this morning?
I have not seen anyone. I only spoke to someone from Lakeshore that's been helping me.
Ma'am, I haven't seen the attorney yet this morning. The matter is scheduled at 10:15. This court's
Yes, ma'am.
policy is 15 minutes after the scheduled start time, okay?
Okay.
Thank you.
So you want me to do what?
Just sit there until I call your case.
Okay.
Mr. Bearcat, Grant, did you need to speak to Taylor Lipford or have you already spoken?
I have not spoken to her directly. That would be helpful, I think. And then also our manager, Kathy McCoy, should be here shortly.
I'm sorry.
I'm sorry if you can't hear me. Yes, I would like to speak to her briefly.
Marianne will get you into a breakout room.
Thank you.
You're welcome. Yep, Joe Horka, Mr. Horka.
Morning, Honor.
Good morning, sir. This is 220223 LT. This is Walter Sikowski as represented the estate of Tana Rouse Hartwell versus all occupants at 49066 Sagoti Pass, Belleville, Michigan. May I have your appearances, please?
Tiara Brewington.
Morning, Honor. Joe Horka, P75969, I represent the plaintiff.
Have the parties had an opportunity to speak this morning?
I have not spoken with Mr. Horka. No, I have not.
Mr. Horka, was speaking to Ms. Brewington be beneficial this morning?
Honestly, 99% of the time I would say yes, Judge, but in this case, I don't think it's necessary, but I'm happy to if you'd like us to.
It's not what I like, sir. It's your case.
I think I'm all set to argue the motion,
The court's
Judge.
ready to proceed. I'm sorry.
I'm ready to argue the motion, Judge.
Ms. Brewington, this is your motion challenging the judgment in this matter.
Yes, ma'am. At this time, I believe that the motion was initially, it was filed extremely prematurely. I do understand that there was a balance that my mom owed that, maybe pushed him to want to sell the property. But we've worked with Medicaid and got that balance deferred. And we're just waiting for a court date to possibly cancel out another heir. And then at that point, we will be the only heirs. And that deferment would benefit us to continue to stay in the home. We have a court date on the 25th in regards to that. It's my mom's estranged ex-husband. He, was gone for years throughout the marriage, and we filed a motion against that to exclude him as an heir. And I'm just saying that I understand, why he may have done it. He did not know all the facts of the case initially, but I'm asking that, we at least hear what our initial judge has to say in regards to all of that. We haven't been before her in almost a year, and we are going before her on the 25th of this month. And I'm asking that we at least hear what she has to say, because if he is excluded, my brother and I will be the only heirs.
Anything else, ma'am?
That would be all for me.
Mr. Horka.
Another occupant brought a probate concern to the court's attention last time, but because the occupant did not provide these documents to my office, to my client, to the court entered a judgment. There was no stay in place. There was nothing presented to substantiate any claims that the PR is about to be removed, that it's appropriate, that anything is improper in this action here. The defendant's motion is meritless. If she's filing a motion to set aside default, then she's failed to demonstrate good cause and meritorious defense. If she's filing under MCR 2.612, she's failed to articulate a cause of action under that. There's been nothing that's changed since this court properly entered a judgment. Any motion that was filed was untimely. This court entered a judgment on March 25th, and a motion wasn't filed until April 8th. And 4.201M requires any post-judgment motions to be filed within 10 days of entry of judgment. The fact that they might have some type of springing interest, some type of change in circumstances, does not change what's here present today. And the court still to this day, I have not been served with any type of documents that go along with the probate action. So I have no clue what's going on there. And I don't know if the court does. So at this point, I would ask the court to deny the motion and permit the judgment to stand as is.
Ms. Brewington, is there anything else you'd like to say to the court this morning?
Yes, ma'am. It is on the court view. I'm not understanding why he's saying that there isn't a court a hearing on the 25th. There is a hearing. I have presented those documents to the courts. I've sent the courts the court view exactly of the court case that I'm speaking about. So I mean, he can say these things, and this is exactly what I'm talking about. Like I said, we're being extremely pressured, extremely muscled into things that, you know, can really, you know, tear apart everything my mom worked hard for. We do have a court case on the 25th. And if anything, I am waiting to hear from the judge. And he knows that. And he knows all about that. And I've presented those court records on to the courts about the upcoming court cases. They have been adjourned. They have been rescheduled. It's out of my hands. But we are waiting for someone to be excluded. And that does leave my brother and I. And the personal representative, he's the lawyer for our personal representative. But we have sent over the papers where we have been deferred from that payment. He really doesn't. We have done everything.
Ms. Brewington, here's this court's question. Do you live at the property 49066?
Yes, ma'am.
Is there a reason why you did not appear previously?
Yes, ma'am. It said all occupants. I had no idea about it. And I did come down there, and I came right after. I was at work. I had no idea. Most of the papers that he has sent here, if it doesn't have it had all occupants on it. But if it does not say our names on it, it goes straight to him. And he doesn't tell us anything.
It goes straight to who?
To the personal representative. He has the mail forwarded from the mailbox if it doesn't have our particular names on it. So the fact that it had all occupants on it, that went straight to him.
Ma'am, I asked you, did you live there? Because there had been another occupant who has appeared and identified himself on the record previously.
Yes, he
where Stanford Salahuddin. I'm not saying the name right.
Salahuddin.
So, thank you. Has appeared as far back as February 9, 2022, here with me, but it appeared on Zoom. So here's the issue from this court's perspective. The court has to agree with Mr. Horka that the motion was not filed timely. Because there was this other outstanding issue of the probate court, the court had allowed some opportunity for the other occupant of the property to retain an attorney and appear again. When the parties came back on March 23rd, 2022, there had been nothing received by this court that indicated that the notice to quit that had previously been served upon the parties, upon the tenants, was invalid. There have been no documents filed with this court that would suggest that this court could not go forward in entering a judgment in this matter. The court will adopt the argument of the plaintiff and deny the defense motion to set aside the set aside the judgment that entered on March the 25th, 2022. Anything else on behalf of the plaintiff?
I will just note, the defendants, I believe, dropped some type of documents off to my client last Thursday or Friday. I don't know what they were, but there have been some documents served. I have not reviewed the court view, ma'am. So I'm going off what I've been presented here, and that's been a lack of documentation to support any type of probate action. So I thank you, Judge.
Ms. Brewington, if there is something else, some higher court that directs this court to do something else, of course, we'll adopt that. But at this time, the court is denying the motion to set aside the default judgment, and will sign the order submitted. If the plaintiff's office will submit an order, the court will sign it.
Will we be able to get a set aside time?
What do you mean?
Is it okay if we get time to, you said you are adopting his motion to leave?
No, Mr. Horka's arguments regarding the basis for denial of the motion to set aside default judgment, the court saying that your motion is denied. Plaintiff's office will submit an order denying your motion.
Oh, okay. So where do I go from here? Is what I'm asking. I'm kind of confused. I'm sorry.
Typically, what happens when the motion to set aside the default judgment is denied in a possession case, the next step is that the plaintiff's office may file a request to have you removed from the property in order of eviction. But because there is this other outstanding issue, I don't know that Mr. Horka or his client, what their next move would be. This court cannot direct how plaintiffs moves forward in terms of possession of the property.
Okay.
Okay.
Well, thank you, Your
Anything
Honor.
else, Ms. Brewington?
That'll be all for me.
Have a good day.
Ms. Brewington, I'm open to you contacting my office and I can discuss things further with my client. So do not hesitate to do that.
We're gonna break up.
Can we speak with you in the breakout room?
I'm okay with that, Judge, if you want to set us in a breakout room.
Marianne will facilitate that. I'll hold on to the file until you come back out. This is 220381 LT. This is MIMG Gateway Townhomes versus Taylor Lipford.
Yes, Your Honor, John Bernkrandt for Gateway, and Ms. Lipford and I have talked in the breakout room. We're in agreement on the entry of a consent judgment. The balance owing, including May's rent, would be $2,687, $167 in court costs, for a total redemption figure of $2,854, which must be paid on or before May 13, 2022. Otherwise, an order of eviction could be entered by the court. I've explained to her that she has 3 business days to contact the court to ask the court not to enter such a judgment, and then we could have another hearing. I did submit a proposed judgment yesterday. I'm not sure it made it to the court file as of yet.
Ms. Lipford, would you state your name for the record, please?
My name is Taylor Lipford.
You've heard the comments just made by the attorney,
Yes, ma'am.
and it's your agreement that $2,687 is due in past due rent
Yes.
and $167 in court costs.
Yes, ma'am.
The case was scheduled this morning on plaintiff's request to set aside the Sarah stay. That stay wouldn't have been placed on February 9, 2022. 82 days have passed since that stay entered. The stay form that was sent to you indicates that if plaintiff does not receive payment in full within 45 days, that the plaintiff could file a request with the court to lift the stay. Ma'am, what's the status of your Sarah application?
I did the first application wrong, and I didn't know that I was supposed to do a research. So now that I did the research, that I'm just waiting on them. I already contacted someone in the Sarah program, and they're escalating it right now.
I can address, add some additional information to that if you'd like, Your Honor.
I'm sorry?
I can address that. Management has brought me up to speed on that application. If you desire, the application was denied. And as of the 29th of April, our manager was in touch with the supervisor at Sarah, who checked in the Sarah system, and the system indicated that there is no pending application.
Hi, John.
Hang on.
No. No. Respectfully, Ms. McCoy. Your client's trying to address you, and I'm not sure why. This court's perspective is that in as much as Ms. Lipford acknowledges and agrees that the amount of rent due is $2,687, and you on the record have indicated that you explained to her MCR 4.201I, this court has received the proposed judgment in this matter and will be signing it. Ms. Lipford, the next step in these proceedings is that you will get a signed copy of this court's order, this judgment in this matter, and if that helps to elevate your case for processing with the Sarah entity, the court will wish you well in that regards. Is there anything else on behalf of the plaintiff?
Nothing further, Your Honor. Thank you.
Anything else on behalf of yourself, Ms. Lipford?
No, so I'm just wanting to, before we get off I just wanted to get a better understanding. So you're saying that what he discussed already, that's what you're doing?
Yes, ma'am.
Okay, I
What he
just wanted
said
to
on the
make,
record.
yes, ma'am. Okay,
Yes, ma'am. That's what we were doing.
okay, thank you.
Thank you. Have a good day.
You too.
Ms. McLemore,
Yes.
are we
Your Honor.
ready on Perry?
Yes, we are. Your Honor, I have had an opportunity to speak with my client as well as Mr. Joseph.
I'm sorry, Ms. McLemore, give me 1 second. I didn't actually call the case. I just had not seen Mr. Herman. I forgot about Mr. Joseph. This is 220346 LT, Southport Apartments versus Jabril Perry. May I have your appearances, please?
Thank you, Joe Joseph, on behalf of the plaintiff.
And Danette McLemore appearing on behalf of the defendant, Your Honor. We did get a chance to speak. I'm sorry, Your
You
Honor.
were starting to say.
We had an opportunity to speak and we basically discussed entering into a conditional dismissal in this matter, and Mr. Joseph provided me with the information. My client is in agreement and we would like to do that, Your Honor. There would be a conditional dismissal entered with payment due by May 27th.
And the amounts on the conditional dismissal?
Sure, Judge, the amount that's due, $3,141 in costs. I'm sorry, in rent to retain cost of $154 for a total amount of $3,295. And in addition, it would be paragraph 4B that controls a default.
That's correct, Your Honor. That is our agreement.
Parties having appeared this morning, the attorneys indicating that a conditional dismissal will be filed with the court with rent to retain of $3,141, court costs of $154, for a total of $3,295 with a pay by date of May 27, 2022, with paragraph 4B controlling. That notation has been made in the file. Once the parties have signed a conditional dismissal, email it to the court civil department. The court will sign it and get copies out to the parties. Anything else, Mr. Joseph?
Danette, do you want us to submit it, or are you going to submit it to us for our review?
Well, if you could submit it to me, that'd be great.
Okay,
I'll
we'll do that.
review it and sign it right away. Thank you.
Sounds good. Thank you.
Anything else, Ms. McLemore?
No, thank you, Your Honor.
Thank you, ma'am.
All right, have a great day.
You too. Mr. Perry, good luck to you, sir.
Thank you.
Have we seen Mr. Landau this morning?
I have not.
Judge,
This is,
for Mr. Landau, if there are cases for him, I know I was handling some other cases in another court, so I don't know if they don't have notice, but I can contact him real quick.
Charlene Kroger. If you want to do that, Mr. Joseph, that's fine. I'll pass the matter. The defendant has not appeared yet this morning.
What is the name on it?
Charlene Kroger.
Okay, and who is the plaintiff?
Bell Villa.
Very good. I'll give them a call real quick, and if
Wait
you're
1 second, because I'm gonna call this case because Ms. McLeod's been waiting. This is 220291 LT Southport versus Hemingway McLeod.
Thank you, Judge. Joe Joseph on behalf of the plaintiff.
Ma'am, unmute yourself and state your name for the record.
My name is Shanika Hemingway McLeod.
Thank you.
You're
Today is
welcome.
the day and time set for hearing on the plaintiff's request to lift the Sarah stay that was filed prematurely.
I'm sorry.
Mr. Joseph, what's the status of this matter?
Well, it was my indications from our notes that the 45 days has passed. And that's why there was a request to lift the stay. Is it this Is it the court's position that we are within the 45 days still?
Yes, we are.
I reviewed the file and my notes indicate that the stay went into place on March the 23rd, 2022.
Yes, ma'am.
And the request to lift the stay was actually received by this court on April 13th, which is 19 days later. Today is actually 41 days from entry of the stay. So we're not even at the 45 days yet. So I'm not sure who jumped the gun. But this court's going to leave the stay in place and will happily adjourn this to our next docket date, which will put us on June the 7th at 10 a.m. Ma'am, that gives you an opportunity to follow up with the Sarah.
Yes,
whomever
ma'am.
you made your Sarah application with.
Yes, ma'am. Your Honor, I have a question for you.
Yes, ma'am.
I spoke to legal aid with Lakeshore, and I was kind of confused because I applied with the Sarah and I submitted. I'm in my second lease now. My lease was due to re-sign by March the 12th this year. So I signed before that. I printed out my new lease for 2022. During the Sarah stay, I received a letter just recently saying that I'm being charged for month to month now, but I'm actually in a lease agreement for $1,024. That's my lease pay. But now they're charging me as far as I'm staying month to month. So I submitted the lease to Sarah, and I also applied with ERAP 2 weeks ago because I haven't heard from Sarah. So I applied with the ERAP as well, and I submitted my lease. Now, what do I do as far as that if they're saying, no, we're charging you month to month, but I'm actually in a lease agreement?
Ma'am, it sounds like you're disputing the charges, which is not why we're here today. Today is just about lifting the stay. If
Yes,
you want to
ma'am.
raise that issue when we come back on June the 7th at 10 a.m., the court will happily hear it at that time, okay?
Yes, ma'am. I apologize.
Anything else, Mr. Joseph, in this matter?
Nothing further, Judge, and I'll look into why that was a premature request to lift the stay. My guess is it probably got entered as February 23rd or a different date altogether, but we'll make note of it. We'll see you on the 7th of June.
Thank you much, ma'am. You may log off. Thank you for your patience this morning.
Okay.
This is 215371LT.
Thank you all.
This is GPM Property Management versus Carol Chambers and Marquita Chambers.
Good morning, Your Honor. Hamza Silva, GPM Property Management.
I'm here.
I'm who?
Hello?
Ma'am, you have to state your name. It's just not I'm here.
Oh, sorry. Marquita Chambers and Carol Chambers.
Could you turn your video on for me, please?
Yes, ma'am.
Today is the day and time for hearing on plaintiff's request to lift the Sarah stay. That stay went into place back on December 20th, 2021. 131 days have passed since entry of that stay. Mr. Soba, has your client received payment of the past due rent in this matter?
We haven't received payment, but according to Ms. Chambers, that they've been approved for Sarah on April the 12th. But our client hasn't received any of that payment. So we'll leave it to the court's discretion on whether or not to lift the stay and proceed with proceedings or adjourn it until we do get payment.
The plaintiff's request to lift the stay is not the court's decision, sir. How do you wish to proceed? Do you wish to proceed with the lifting of the
Well,
stay?
yeah, we would
Requesting
definitely
adjournment?
lift. No, we would definitely want to lift the stay and proceed.
Ms. Chambers, I'm sorry, Mr. Soba, how much rent is due and owing at this time?
10,400. Well, in rent, $10,216.95. But including costs, it'd be $10,401.95.
I'm sorry, what are the actual costs?
The court cost, the filing fees, which is $185.
Ms. Chambers,
Yes, ma'am.
is there $10,216.95 in rent due and owing?
Yes, ma'am.
And the other, Ms. Chambers, admits that
Yes.
that's how much rent is due and owing?
Yes. Yes, ma'am.
Have you followed up with the Sarah agency to determine?
Well, they
when this
sent
check
us
would be-
a approval letter sent. Tell her. It was approved on the 12th, so they said it could take 2 to 3 weeks for the payment to post.
It was approved in what amount?
It was approved for rental arrears of $8,105.50, and then future rent of $3,622.50.
Today would be the third week.
I'm sorry, did you get that?
I did. Thank you, ma'am.
Hello?
I'm here.
You get that I said, ma'am?
I did. The future rent of $3,622.50 and the pass-through rent of $8,105.50. What the court will indicate is that we are 131 days since entry of the stay. Plaintiff's position is that they have not received the payment within the 45 days allowed by the stay. The court is going to lift the stay and enter judgment in this matter with the rental amounts placed on the record by Mr. Soba, that being $10,216.95 in rent to retain, $185 in court costs. That's $10,401.95. Plaintiff's office to submit that judgment.
Thank you, Your Honor.
Anything else on behalf of the plaintiff?
Nothing, Your Honor. Thank you.
Ms. Chambers, anything else?
They're not going to accept the check that Sarah is sending? I'm not understanding.
Ma'am, they will accept the check and they'll apply it to the balances due and owing. The Sarah program allowed for the stay, which allowed time for the application to be processed and the payment to be remitted. But the plaintiff is not required to wait indefinitely for receipt of the money. This case has been adjourned, had been in stay since December. So if you've indicated that the payment was approved on April the 13th, the check should be arriving at plaintiff's office at any time now. And what they'll do is they'll apply it against the balance.
Okay.
Anything else, Ms. Chambers?
Does that keep us in our house, or I'm not sure?
Well, you can contact us and we'll talk to you about what's going to happen moving forward.
Okay.
Once we get the check, what's going to happen?
We have to contact them.
Ms. Chambers, the judgment will indicate. The judgment will indicate that this is the amount that's due and owing, the $10,401.95. And usually the plaintiffs include 10 days to pay. So when you get a copy of that judgment, what I would suggest to you is that you follow up with the Sarah agency to make sure that that payment has been made. Because otherwise the plaintiff, if they don't receive the payment in the 10 days, they could file a request with the court to move towards eviction.
Okay, I understand.
Okay. Anything else, ma'am?
No, thank you.
So what
Thank
you
you, Your
saying?
Honor.
Thank you.
Thank you, Your Honor.
Have a good day.
You as well. Thank you.
Thank you. Mr. Landau, good morning, sir.
Good morning, Your Honor. How are you today?
I am wonderful. Thank you to Mr. Joseph for calling you. This is 220405 LT. This is Belleville versus Charlene Kroger.
Mark Land on behalf of the plaintiff.
Today was the day and time scheduled for hearing on the plaintiff's request to lift the Sarah stay that went into place on February 9, 2022. 82 days have passed since entry of that stay. Charlene Kroger, this matter having been scheduled at 10:15, it now being 10:51 a.m. by the court's clock. Defendant having failed to appear, sir, how do you wish to proceed?
Your Honor, we are requesting the entry of a default judgment of possession for non-payment of rent. The rent owing is $5,943.12 plus $155 in costs. Total is $6,098.12.
Defendant having failed to appear as directed by this court, plaintiff indicating that payment has not been received. Sarah stay is lifted. Default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $5,943.12, $155 in court costs for a total of $6,098.12. Plaintiff's office to submit that default judgment. Anything else on this matter, Mr. Landau?
Nothing further, Your Honor. Thank you so much.
We received the dismissals of your other two matters. I believe that that concludes your docket with me this morning, sir. Have a good day.
It does. Thank you. We'll see you tomorrow.
Thank you. Yes, sir. This is 220225. I'm sorry, Geraldine O'Brien? Your hand
Yes.
is up?
Yes, I was just hoping that you hadn't forgotten me for the day.
No, ma'am, I was calling the 1015 case. I'm calling the 1030 case right now. This is 220225 LT, Geraldine O'Brien versus Ashley Wilson.
Yes, ma'am.
State your name for me.
Geraldine O'Brien.
Miss O'Brien, today is the day and time set for. What happened to your attorney, ma'am?
He was costing me too much money. I had to let him go.
Today is the day and time set for a hearing on plaintiff's request to lift the Sarah stay. That stay has been in place since February 2nd, 2022. 89 days have passed. Miss O'Brien, have you received payment of the past due rent in this matter?
No, ma'am. She doesn't qualify, nor do I. Only thing I'm asking for the court for today is for her to be evicted from my home. And if you could make it as soon as possible, or even today, I would be very grateful. She's been in my home for like 7 months, and I've been paying the rent, lot rent, and for the water, sewer, and garbage for the past 7 months, and I wish to have my home back.
Miss O'Brien, the matter before the court this morning is the request to lift the Sarah stay. The court will lift the Sarah stay and enter judgment in this matter. Ma'am, how much rent is due and owing?
More than $5,000, but I won't receive that because, like I said, she nor I qualify for Sarah because.
Miss O'Brien?
Yes.
This is a non-payment of rent case. So the judgment that the court enters will have the rent on it and your court costs to date, and you will have, the defendant will have 10 days to pay or move. So when you say more than $5,000, that's the judgment has to have an exact dollar amount. How much money is due and owing on past due rent?
I don't look to collect that rent, so I don't see that rent, that amount is bearable in this case because she's
I'm sorry,
not.
That amount is not what?
That doesn't apply to me in my situation because I'm leasing the lot and I own the trailer, and my lease agreement says that I'm not allowed to rent. So with that in mind, when I applied for Sarah and they asked me to contact Bayshore Homes, who owns the property, and tell them my situation. And I said, well, Bayshore Homes has a clause in the lease agreement that says no renting, sub-renting, subleasing is allowed. So for that reason, I won't be able to receive Sarah, and neither will she, because neither one of us will qualify. The only thing I'm asking for today is to have my home back and the furnishings that are in the home, since it was rented to her with my furnishings, my furniture, and also not to leave my house destroyed as she leaves to go somewhere else.
Ms. O'Brien, what I'm saying to you is that that's not the type of case you filed. The case you filed, give me 1 second. The case you filed is about money. Because you filed the non-payment of rent notice. And then
Yes,
there's a Sarah application, the case was stayed. So Ms. Wilson has not appeared this morning. The court is prepared to enter a default judgment. That default judgment has to indicate that there is rent due to the plaintiff landlord in a specific dollar amount.
Well,
and if that's not how you,
I've already explained that I'm not asked. I'm asking her to leave my home, and so that because I own the home and it's my home, And I would like to move back into my home. And that's all that I want today. As far as money, I was assuming that was the money judgment was for her qualifying for Sarah. And since she doesn't qualify for Sarah, and neither do I, then there will be no money exchange. So there will be no money involved because I won't get paid, and so there's no judgment. There should be no judgment. The non-payment is not will not be my the reason why I'm asking her to leave. The non-payment is
Miss O'Brien, I'm cutting you off because I understand what you're saying. I'm not disagreeing with what you're saying.
Well,
and this is why, hold on one second. This is why, although you say the attorney was costing you too much money, the attorney understood the process. There are two different types of landlord-tenant cases. The case you filed is a non-payment case, which indicates to Ms. Wilson that if she pays, she can stay. The other type of case is determination, whereas I just want my property back. And once you start on the path of if you pay, you can stay, that's the path we stay on. So if what you're saying to me this morning is that it's not about the money anymore, then you're abandoning the case that we're here for. If you want to start another case, that's determination, that's your absolute right. But for right now, she's not here and you're here. My question to you is, do you want a judgment that if she doesn't pay that judgment amount within 10 days, you can come back and file a request for an order of eviction? Or do you want to dismiss this case and start a termination case? Those are your two options this morning.
I would like, is it 10 days? Does it have to be, can it not be 5 days?
No, ma'am, it's 10 days minimum by law.
So she gets to stay in she gets to continue to stay in my home for 10 days. And then when I come back and ask for you to evict her, for what? What is my reason?
Non-payment of the judgment, ma'am.
So you're gonna ask her to pay it, and then if she doesn't pay it, then she has to leave in 10 days?
Ms. O'Brien, I have given you as much direction as the court's allowed to do. The court's not allowed to provide you assistance in proceeding on your complaint for non-payment.
I'm not asking. I'm just trying to understand. I'm supposed to, the court is going to send her a statement saying that she needs to pay me, right? Or leave.
Correct.
Okay.
Correct.
And if she doesn't pay me, then in 10 days, she will have to leave.
You will have to take additional action. So Ms. O'Brien, I'm going to ask you for the fourth and last time. How much rent is due and owing from Ms. Wilson?
$5,000.
And the court sees a filing fee of $55 and a service fee of $34. Have you had any other court costs in this matter?
No, ma'am.
$89 in costs. The judgment will be $5,089.
Thank you, Your Honor.
And you need to submit that to the clerk's office for entry. If you have questions about how to do that.
Yes, I do. How to submit that?
You'll call the civil department of the clerks of the court office, okay?
Okay.
And they'll know the amounts I've written in the file, and they'll provide you copies of the paperwork that you need to submit, okay?
Yes, ma'am. Thank you.
Anything else, Ms. O'Brien?
No, that's it. Thank you.
Thank you, ma'am. Have a good day. Ms. Roth.
Hello, actually, it's Darlene Hall.
Darlene Hall. Oh,
Loretta Wright, Darlene Hall.
yes, ma'am. Yes, ma'am. Yes, ma'am. And I see Mr. Morton is here right now. Mr. Morton,
Sorry,
have you had an opportunity to speak this morning? It looks like you just joined us.
That's correct, Your Honor. I would look forward to an opportunity to speak with Ms. Hall briefly on this matter. I know that we had a requirement to provide documentation, including witness and exhibit list, which I know we submitted from our office. But if you'd like to put us into a breakout room, that would be wonderful.
Mary Ann will get you moved into a breakout room. I'll be back out in just a few moments.
Okay, thank you.
Okay.
So Mary Ann,
Yes, ma'am.
there is a house on Belleville Road as you're going south towards the bridge. It's on your left-hand side. They have this giant skeleton that they decorate. When I say giant, I mean 20 feet tall, that they decorate, that they
I saw it.
decorate for the, it's dressed for Memorial Day now. It's dressed in red, white, and blue. I don't know who lives there, but I swear the amount of energy that you put into decorating, I'm jealous because I can't get this change back here to be seasonal. And you get out in your yard and you have these humongous, it's not just the skeleton, they have other stuff out there. It's wild to me.
I saw the Easter bunny, the really big Easter bunnies. Like they are having fun, and hopefully they have little kids.
I don't know who lives there. I know when the house was last sold, you could tell there was a lot of work they were doing. They cleared out the foliage in front so you could see the house real well, but that giant skeleton, I thought just showed up this last Halloween, but they've had it dressed in different stuff over the last 6 months now. I just saw a picture of it and I just think it's hilarious. This is 220932 LT. This is Rawsonville Woods versus the original defendant was listed as Loretta Wright, but I understand and our notes indicate that Ms. Darlene Hall has appeared historically in this matter. May I have your appearances, please?
Excuse me?
Mr. Morton, state your name for the record.
Your Honor, for the record, Attorney Ian Morton of Pallets Law on behalf of Rawsonville Woods.
And Ms. Hall, if you would state your name for the record.
My name is Darlene Ann Hall.
Thank you. The parties have had an opportunity to speak this morning. The case was scheduled for bench trial. Mr. Morton, how are we proceeding this morning, sir?
Your Honor, the parties have spoken and we've agreed to enter into a proposed conditional dismissal. May I put the terms in the record?
Absolutely.
Thank you. We've agreed that a conditional dismissal will be entered with a payment date of May 20th, 2022. Was it rents retained are $4,652.46, core costs of $164, total of $4,816.46. Procedurally, Ms. Wright will be formally dismissed as she has passed away. And then we will keep this this conditional dismissal as to all occupants only. Ms. Hall has confirmed that she would consider herself an occupant at the premises. And again, this is an agreement, was it to provide an opportunity for that payment to be made and the balance to be brought current. Also, additionally, Your Honor, I did advise Ms. Hall that in order for the tenancy to continue beyond this point after the payment, they would need to submit an application to be approved for tenancy at this point, based on the fact that Ms. Wright has passed away. And I explained to Ms. Hall, so she understands this, I'm gonna put this on the record. Before my client can take any action whatsoever, was it a judgment and order of eviction would have to be entered. And in this case, if that balance is paid by the 20th, this case is done and no further action could be taken on it. So if they wanted to take additional action, they would have to issue a new notice and file a new case.
Ms. Hall, were you able to hear Mr. Morton just now?
Oh, yes, ma'am.
And that's your agreement, the entry of a conditional dismissal where $4,816.46 is due and owing?
Yes, ma'am.
That's $4,652.46 in rent, $164 in costs, and the pay by date is May the 20th, 2022?
Yes, ma'am.
And ma'am, you'll be able to pay that amount by that time?
Oh, yeah. Oh, yes, yes. I have the money. It wasn't the issue, but it's just like Ian was saying, is that, they want their rent money, and I understand that. It's all the other things that I'm going through with the court over my sister being autistic and everything else and not wanting to lose her place of living. So, but I can visit that after I get this rent paid and get this judgment off of there and just start put the application in and everything and just try to work with them a little bit better and see if we can get this straightened out.
Thank you, ma'am. And thank you for being here this morning and representing your family in this way. Mr. Morton, the court will await receipt of the conditional dismissal.
Absolutely, Your
Anything
Honor. I
else
did
on
advise
behalf
her
of the
rights
plaintiff?
under MCR 4.201 as it will not be final for 3 days.
Thank you. You heard
Thank
that,
you, Your
Ms.
Honor.
Hall?
Yes, I did, ma'am.
Anything else, Ms. Hall?
No.
Thank you so much. Mr. Morton, thank you so much for your assistance in getting this matter resolved. You both have a wonderful afternoon, okay?
Thank you, Your Honor.
You have a nice Mother's Day, Honor.
Thank you, ma'am. Mary Ann, that concludes our docket. Our afternoon are both live, so I'll take us down. Thank you very much, ma'am.